Thank you for having me. It's an honor to be here with friends. I mean, there's a lot of times where we are in the room with folks that are a little adversarial, and so yes, there's that. Just like groundwater data, I think board meetings can be sexy, but you don't want them to be. So we're going to talk about how to run a smooth board meeting and an unsexy board meeting. I learned a lot of these tips, tricks, I think most importantly the law about board meetings from representing Texas cities. So I was a municipal lawyer for about 6 years before I really jumped into water law. And I would say that a lot of the tips you'll hear, a lot of the law is transferable. All local governments are going to be subject to this kind of stuff. So let's talk about boards. Okay. So I want to go back to kind of the foundation of what a board is to inform how to have successful meetings. So the Texas Constitution says that districts shall be governmental bodies and also bodies politic. And so this means there's 3 definitions of bodies politic in Webster, but the one that I thought was most appropriate is that they're considered a collective unit. They act together. This doesn't mean that there won't be disagreement, because there will be. But this means that you're acting collectively in front of the public. And so one thing that's important is that the public knows what the unit is considering and what the action the unit is taking. So you'll kind of hear that theme throughout this talk. So GCD boards are vital. You can't get rid of your board. And they're vital because it's the board that sets the rules and the policy to accomplish the district purpose. And so I'm not going to read the whole purpose, because I'm sure you've heard it a few times. Lawyers love to cite it. But essentially, it's the 6-part purpose to provide for conservation, preservation, protection, recharging, and prevention of waste of groundwater, and to control subsidence. That goes further, states that districts are the preferred method of managing groundwater. And the district boards are those that set the rules and the policy in order to do that. So it's nobody else, it's the board. These policies and rules and really your actions go through a democratic public governance process. So Chapter 36 in the Texas Constitution, they basically say that you boards are subject to open government laws that allow for public participation on the items you're considering and the actions of the collective unit. So another reason you can't get rid of your board is that they're legally required. So Chapter 36 makes boards essentially responsible for all affairs of the district. There are many affairs of the district in Chapter 36, and there's some outside of Chapter 36. So you're going to look at your enabling legislation. You'll look at Open Meetings Act and Texas Government Code as well for responsibilities of the district. But essentially, the board is the one that handles its own business. You can delegate, and we'll talk a little bit about that later, and the delegation really goes a long way in having effective meetings. Okay, so let's talk about who the players are with respect to your district. This isn't necessarily meetings, but you'll also see some of these players at your meetings. One, you've got the board officials. These directors can be elected or they can be appointed. Some districts you might have both. If you've got directors elected and then you're filling a vacancy, you'll have appointment too. I don't want to get into corporate structure. But the next, I think, is really important is your constituents. And I like to think of these as the folks that own property or have a water right that Chapter 36 says the board has to protect that private property right. So I consider those to be constituents. You'll have applicants and vendors before the board. These, in some situations, these are also the ones with private property rights to be protected, either by ownership or lease. And these folks can also be vendors. Folks wanting to provide services to the district, they have to come before the board in order to have their contracts for services considered and approved. The next big important group are special interest groups. These are typically groups that are presenting information and trying to convince the board on policy one way or another. And they typically are involved in rulemaking, involved in stakeholder groups if one is set up by your district. And sometimes they also get involved with permit actions. Regulators. Heather loves this part. Districts interface with local and regional groups as well. So you've got your regional water planning groups that you've heard of, your groundwater management areas, and as well the counties that cover the district where the district lies. You'll have state groups, Texas Water Development Board. We just heard about data collection and submission. And as well, you'll be interfacing with them on planning efforts and the adoption of the management plan. TCQ has some oversight as well. And one of my favorites, there's some sarcasm, the State Auditor's Office has a right to audit the district. So there's also just a very minor, rare interaction with federal groups. I've once received a call from the U.S. Fish and Wildlife Service to figure out if our district's rules were protective of a special toad. They didn't have to be, but they sure enough made the call and said, I don't think your rules are protective of this toad. It's like, okay. Anyway, so these entities generally don't attend your meetings. Another group is the media, and I represented about 20 cities before representing groundwater districts, and I never received media calls. But a couple of months into representing districts, I start receiving these calls. It's, when water is in high demand all across the state, everywhere, and it's the district's business to manage groundwater, these topics are going to be of significant interest to the media, and they may be at your meetings. Utilities, political subdivisions, cities, there will be some utilities that are permit holders in your district that produce water in order to serve within their service area. They may be also at your meetings. Neighboring communities are another group, your fellow districts in your GMA. And then the judiciary, you may have a relationship with them, not really a relationship, but you may have issues before them. The district directors can be sued. If you want, I don't want to get into that, but if you want to learn more about that, you should read 36.066. And Tagged has some very useful resources on their website about director liability. So I'm mostly here speaking about district court judges, even federal court judges, if you have some sort of judicial review appeal. But on the local level, with county commissioners and county judges, you're not really going to have that type of adversarial situation. The public. I consider the public to be all of these except for the board. All of these groups are going to be entitled to the same information and the same right to transparency under Texas law. So I treat all of them as the public. So what's your official position? Did I skip? I did not skip. Okay. So to effectively run the meeting, it's really good to know what's expected of you. as a board member or as a board president. Also, essentially, kind of what limitations are on you as staff or a member of the public. The president under 36 is your presiding officer unless she designates that duty to someone else. She'll call the meeting to order, she'll call the items, and she'll adjourn. I wish it was all that simple. Everything in between, though, is where we have to meet the procedures that apply to districts. And these procedures are housed in the Open Meetings Act, they're in 36, and in some districts, they're in rules. And so some districts have adopted like a public participation structure that has rules that impart on governance. I think there's kind of a misconception that Robert's Rules is a requirement to follow. It is often used as a treatise. It's very helpful, but it is not required that you follow Robert's Rules. One thing that you have to do if you're going to follow Robert's Rules is to make sure that there's not a conflict between the Open Meetings Act, Chapter 36, and your own rules. And so one of those would be what Robert's Rules says is a quorum versus what 36 says is a quorum. And we'll talk a little bit about that later. Oh. Okay. I'm pointing in all sorts of ways, but I need to be pointing in the back. Okay. So board members, essentially board members, yes, really need to show up and need to be informed of each agenda item. And we'll talk about preparation later. But the board's responsibilities, which we discussed, really the only opportunity in order to implement those responsibilities is at your meetings. And so you need to attend meetings and be engaged. As far as staff goes, typically staff does not run the meeting unless delegated by the presiding officer, but they work to prepare the items for a consideration for the board. And so kind of given their closeness with the preparation, oftentimes they're asked to report or give a written recommendation to the board at the meeting. Applicants are often present when they need something from you, when there's a new permit or permit amendment, really just anything. If a president so chooses or presiding officer so chooses, the applicant will be given the opportunity to present on their item or on their request and be available for board questions. A lot of times, like this is kind of like a fluid process. I recommend that whatever practice is established is one that's applied to all applicants. And so this would be another situation where you might adopt a rule allowing the applicants time to present. The audience, generally the public, you can have observers. The media, we spoke about them. They can tape record, they can videotape, but they can't do that for closed session. I've had that try to happen before, and so you've got to ask them to stop recording. You can also ask them to stop recording if the recording is disrupting the meeting, and it's rare that happens, but you do have that right. Experts and consultants, you may have your hydrogeologist at the meeting. Oftentimes staff or president will invite them there. They may be there on a regular basis as well, really to inform the board on the best available science, because that's what your decisions are supposed to be informed by. So you may have reports by consultants at your meetings. Okay. So this is just a further breakdown of all those different groups. I mean, these are the list of persons that actually might show up at your meetings. Again, I mean, unless there's some sort of relationship, contractual or employment relationship, all of these folks are subject to the same rights as the rights of the public. But you might take stock of who's at your meeting at the beginning of the meeting. And so let's talk a little bit more about function. Okay. So I would make one change to this slide. I think it should be broken down into what is a board member's function and what is the actual board's function. And I am very aware that this is mostly a volunteer job, aside from the $9,000 that Chapter 36 says that you're entitled to. But it is very important to be intimately familiar with your items on the agenda. You get most of the materials in advance. If you're not getting them early enough, you might set a deadline for these board materials to be provided to you. It is helpful to ask questions of staff, consultants, the lawyer in advance of the meeting if you can. And so, as a board member, of course, you have the ability to do that at the meeting, but it is oftentimes a lot smoother if you can have more candid conversations and get your questions answered in advance. So I would say kind of the first 4 bullets are what apply to the board members. You always kind of have to think for each agenda item, is this achieving the purpose of the district? Is this vendor's contract something that we need to help us achieve conservation or recharge or whatever the contract's for? Is it intended to further the purpose of the district? If it's not, what's wrong with it and how can it be fixed? So these are a couple of ways to think about those first 4 bullets. The board being the last several bullets, and we'll kind of talk about how the board's role changes on different items. It's you all listen, you all deliberate to set policy or take actions to achieve the purpose. But like I said earlier, you don't all have to agree. And oftentimes you might end up with a better policy if you don't all agree. But really, you want to think through kind of your adjudicatory role. I hate that word. It's kind of like my cousin is a grocer and he can't say like pistachios, and it's horrible. But anyway, so you want to think, put on that judge's hat, because you will be judging, permit applications and things like that, and go through kind of those factors, like the factors in 36 where 10 minutes, is that a real 10 minutes? Okay, thank you. All right. So anyway, I won't get into too much of that, but the board can also serve as like an appellate body. Some districts have rules where, there can be decisions made by staff or by the GM, but if an applicant's unhappy with how that decision came out, there will be an opportunity to appeal the decision to the board. So put on your appeals hat too. So you wear lots of hats, and if you're prepped for the meeting, you know which hat to wear for which item. Okay, so this is the slide for your presidents or your presiding officer, if the president has delegated it. You're really going to focus on the process. You want to make sure the procedure is right, really above all else, versus the outcome. Because really, I hate to get the call to say, it says, oh, we didn't allow this person the opportunity to give public comment on this item. What does that mean? Is our item not valid because we didn't follow the process? And it's like, well, it might be challenged as invalid because you didn't follow procedure. And so we'd have to redo the vote. So the presiding officer as well, if you have your legal counsel there, they're really going to be focused on process. The president has to have a good grasp of what's the district's limits and what are the district's resources. A lot of times the president's kind of lead introduction of items, and I've had one board where the president committed staff to gauge wells every month district-wide. That district didn't have the resources to do that. So, be careful about the comments you make in an open meeting. And, Another thing is the meeting is for the board members. It's for the board members to deliberate, to set policy, and we don't want to see a presiding officer essentially hog the meeting. Another really important one, I won't go through all of these because I've got like several more slides, is to maintain civility. And the presiding officer is really, that's their job. If someone is being disruptive in the meeting, somebody from the public or another board member, that person can be removed. Now, you're not removing somebody because they are criticizing actions of the board. I mean, you're removing them because they're being belligerent or profane and really disrupting the business of the district. Okay, so all those other things are important too, but I don't have as much time. Okay. So traits of successful board members. We've kind of talked about the first three already. Show up, ask your questions in advance, and be prepared. So we'll look at number 4. It is very important. It's be brave and speak up. It's kind of the concept of there's no stupid question, or, maybe there are other directors thinking about it, but they're not speaking up. This is your chance to inform the policy. And, it really does take sometimes that bravery in order to do that. So the other one I'll touch on is fairness, because the district in several places in Chapter 36 is legally required to be fair and impartial. So when developing your rules, you have to be fair and impartial. When considering transport permits, fair, impartial, and non-discriminatory. So, these kind of themes, I think, impart to your meetings. So you're not giving more time to certain groups when speaking or presenting. So the last bullet, I'll touch on it just briefly. This is really important. If you aren't ready to take action, if you're not informed of the item, or let's say it's consideration of issuing a new permit, you don't feel like the materials provided to you show that there's been an adequate review of existing impacts to existing users, my recommendation would be to not act on it. And hopefully the item could be postponed until, the board is ready to take action. Okay, so remember we talked about the board being the judge, and so that also includes an obligation to not have ex parte conversations. So if let's say you've got a proposal for decision coming back on a contested case application, and you are a board member, you are sitting as judge on that proposal for decision. You can't go and talk to one party. The board would actually have to give notice to all parties for an opportunity to address the board on that item in order to really be good with the prohibition on ex parte conversations. Don't disclose executive session information. Y'all all know that. If it happens in Vegas, it stays in Vegas. And conflicts of interest, I'll briefly touch on that, but it's really not the district's or the district lawyer's job to tell a board member if they have a conflict of interest. So if there's an item on the agenda, and that's why you really have to be careful and review them all. You review it for financial conflicts, property conflicts, or really any other kind of family relationship, ethical conflict. Work that stuff out in advance of the meeting because it's very awkward and inefficient to do that during the meetings. Let's see. Know the law. That's huge. Like, you want to know the standard by which you're making these decisions. And, if you need to consult with your counsel before or your GM and say, wait, which rule really applies here? Is there a rule missing? Wait, am I missing something? Okay. So did I move to the next slide? I did. How many minutes are left? Oh, you let me go over? Awesome. Okay. So traits of a successful board member, really lead with a positive agenda. And so agenda here is not the notice. I'm talking about kind of your motivations and your will to do the purpose of the district. Really kind of come to those meetings with an open mind and positivity and ready to deliberate with your colleagues. Embrace all matters of the board. Everything is equally important. Really be kind of supportive of others' ideas. And one thing that's critical here is sharing data and seeking a consensus if you can. I mean, that might not always be an option. All right. Okay, so meetings. Really, a critical thing here is having some sort of process for getting items on the agenda. So this is really just the agenda page. So you can, in the meeting, you could say, well, okay, any items that you would want to add to a future agenda, that's great. Or, if you haven't thought about it in the meeting, you make sure that you get your items to the GM or presiding officer. Here, Leah's coming to shut me down. Okay, great. Oh, okay. Well, since then, no. So anyway, one thing that's important, and I was talking to Blue Bonnet GCD about this earlier, is having a manageable agenda. Don't pack your agendas. Things to think about are there any legal or regulatory deadlines that require us to, we do have to have this. We do have to take action on this now and this month. Then, of course, yes, it needs to be on the agenda. But things to consider as well are, if you've got something coming up and it's going to be hotly contested or lots of public interest, kind of make time for that deliberation, with the board or even with the public that that you expect a lot of public to attend. So you don't want to have a 30-item, 20-item agenda on a night that you've got something like that. Agenda items should be clear and easy to follow. It should be consistent. That's pretty important. There's not a rule that says be consistent, but there's some case law that says, the public, they have kind of gotten used to a certain structure of your agenda. And so you can't just go change it willy-nilly. That's a legal term. But consistency is really important. Let's see, agenda language should be substantive so that you inform the public of what you're considering, what you're talking about. And agendas should always be accessible. And there's some Open Meetings Act training materials, I believe, on the tagged portal. So I won't get into too much of that. Okay, quorum. Of course, you need a quorum to conduct business. And, you're going to see the quorum requirements in Chapter 36 is majority of your entire membership of the board. So it's not really a quorum. So it's... One thing to consider is if you have a vacancy on the board, your quorum might change. So it's not the actual number of board seats, it's the membership that you have. And let's see. Set expectations for public participation. So this kind of goes back to the idea of establishing rules or some sort of public participation policy. And that will further support the presiding officer when they're making decisions on how much time to give somebody. If it's already decided, the public knows what to expect. Be respectful of each other. That's huge. Let's see. Okay, I think the biggest thing on here is the last thing, is, respect the decision. Your fellow board members have come to this meeting, hopefully prepared, ready to set policy, ready to achieve the purpose of the district. If there's any kind of dissension, really you leave that with the last item and you move on. And so, really, that's a big thing when you're trying to be orderly and conduct meetings. But I will stop there and show you pre-pandemic Natasha. If you have any questions for pre-pandemic Natasha, she can be reached there. But I really do. I appreciate all of you. It's a pleasure serving districts and being invited here.